There are new filings in the Karen Reed case today. It's July 18th, 2024. Remember, there is a hearing in this case July 22nd, Monday. That hearing is supposed to be a trial setting because of the mistrial declared. After the mistrial was declared, Alan Jackson filed a motion and then supplementals stating that 2 jurors had reached out to him directly to say that they had reached verdicts on counts 1 and 3. Counts 1 and 3 did not have lesser includeds like count 2. Count 1 was the second-degree homicide. Count 2 was the hit and run causing death. The jury said that they couldn't decide the charges on count 2. That is the one that had the lesser includeds. Alan Jackson filed those, spoke to 2 jurors. David Yannetti filed a declaration that 2 jurors had spoken, but the information relayed to him came from intermediaries through someone speaking to him. So it was like friend of a friend conversation, and that took more of a minute, or was more, really is a less direct line of communication and more of a game of telephone. The Commonwealth responded and said, there's nothing the court can do. We're not violating Karen Reed's rights. We don't need to inquire into the jurors if they had reached verdicts. We don't need to do any of this. We can retry her on whatever we want to retry her on, and this is why. The defense filed what I thought was a very good reply to that and said, no, not only does justice and law demand that the court dismiss counts 1 and 3, but we should be allowed to inquire as of the jurors if they truly did reach verdicts and just didn't know. They couldn't fill out the verdict forms on counts 1 and 3 and really didn't know to ask. That's not justice. That's not right. And that's not what double jeopardy intended. It didn't intend that everyone does everything perfectly, and that's their argument. The nuance in the middle is that whether inquiring of the split or of the jurors of a verdict, does that go into the improper grounds of asking about their deliberations? And the defense put some good case law in on point that said, this is not how they decided. This is not the nature of their deliberations. This is not the deliberative process. This is not the decision-making process. This is the result of that process. Did you reach a verdict on count 1? Yes or no? Did you reach a verdict on count 2? Yes or no? Did you read a verdict on count 3? Yes or no? And then what was that verdict? That's asking about results, not asking about the deliberative process, and that's the defense's argument. The prosecution is still arguing, I do what I want and we can retry it and it doesn't violate double jeopardy and it's all good. It doesn't matter what the jurors say now. They've been dismissed. It's done. So in that, when we first saw these motions, I said I wouldn't be surprised if additional jurors come forward now that 1 juror has spoken to Alan Jackson. And we have seen other jurors speak to the lawyers or to friends, and those friends disclosed it to the lawyers. Because things are going to continue to move quickly ahead of a hearing on Monday, we now have 2 new filings that we are going to get to. A motion from a juror and a ruling from the court on that motion from the juror. I like that the best. The jurors going directly to the court and being like, how do we resolve this? Affidavit of Juror Doe. Now comes Juror Doe, a pseudonym, who on oath deposes and says as follow. I am of legal age and have personal knowledge of the facts set forth herein. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. I just retained counsel to represent me. I have read the impoundment order entered by the Judge Cannoni on July 8th, which found that, quote, good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. As I read the court's order, it is scheduled to expire on July 18th unless it is extended by the court. I submit this affidavit in support of my request to extend the impoundment order entered on July 8th. I am asking that the impoundment order be extended indefinitely because I am in fear for my personal safety and the personal safety of my family if the names of the jury are made public. I've read the impoundment order and noted on the very first page that individuals associated with this case have been charged criminally with intimidation. I am frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. I also recall testimony from at least 1 witness who described being harassed by individuals and her family being harassed because of their involvement in the case. I do not know any of the specifics of such harassment, but I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. During jury deliberations, we could hear protesters outside screaming and yelling. During the jury service, the members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. After being discharged from jury service on July 1st, we were taken by bus back to what was supposed to have been a secret location where we observed what appeared to be members of the media, including photographers. I was so much in fear on my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but that was and remains my mindset. If juror names are made public, we will be constantly threatened and harassed, and there will likely be a physical confrontation at some point. Since being discharged from jury service on July 1st, I have read multiple news articles about the case and the attention that this case garnered across Massachusetts, New England, and the country. There are clearly people who have very strong opinions about the case and about the jurors who deliberated over many days. I have seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. Some individuals have expressed outrage and anger that the jury did not find the defendant guilty. Just yesterday, I read an article in the Boston Globe with the headline, "Karen Read case ended in mistrial, but the diehards haven't given up. See Exhibit 1. In approximately the 12th paragraph of the article, an administrator of the Karen Read Focus Facebook group was quoted as saying, "The people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at an 11.5. The article characterized this increase as a rising rage. Later in this July 15th Boston Globe article, another individual interviewed by the reporter said, "People are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that an individual will publicize someone's personal information, including someone's residential address, occupation, business address, etc. Publicizing my personal information in this context exposes me and my family to unwanted, likely surprise encounters with strangers who likely will have an axe to grind with any juror. I have seen social media posts that were very demeaning of and attacking the integrity of the trial judge. If someone is going to attack a sitting judge, I see no reason why they would not demean and attack verbally and physically a juror who sat on the jury." He goes on to say, "I understand that there are individuals who are upset that an impoundment order was entered and that they are actively seeking the identity of all the jurors. For example, my attorneys have made me aware of a video posted by a blogger/journalist who I understand to be a person who has been charged with witness intimidation related to this case, speaking about the trial and the jury's inability to reach a unanimous verdict on all counts after the trial. In the video, the blogger initially states that he has identified the jury foreperson in this case. Not only does the blogger state that he has identified the jury foreperson, but also where this person lives and what they do for a living, and then they linked it. In this same video, the blogger demands to know the identity of the expletive idiot on this jury who did not vote in his preferred manner. And further that, whoever did that subverted justice like they helped cover up for a murder. As far as I'm concerned, that's what I think, and a link to the video." The individual states in another video posted to Twitter, "Who outed the Cessna juror? Remember that? The one woman who hung the Michael Cessna trial, footnote 1. The jury lists are public, so I got the jury list and I went down the list and I found the juror who hung the jury. And I shamed her, as I should, because it's shameful. I understand that the above mentioned individual has been accused of harassing witnesses to the case, including by organizing crowds of people to harass them outside their homes. And I am aware that he has made statements in a blog from 2023 to the effect of, quote, "Murderers and those who cover for them do not deserve to live a comfortable life, while Karen Read suffers and fights for justice for John O'Keefe." See Exhibit 2, so there's an attached exhibit. If, as he has stated, this blogger believes that members of the jury on which I served, quote, "helped cover up for a murderer," and he further believes that, quote, "those who cover for murderers are legitimate targets of harassment," I fully expect that members of the jury will be subjected to efforts to harass and shame them, with the very real probability that some physical confrontation will inevitably occur. My concerns are not limited to a particular blogger or to a particular, quote, "side" of this case. I am aware that there are outspoken bloggers, commentators, and groups of people who wished for a guilty verdict on some or all of the charges against defendant. I am aware that there have been physical confrontations between the two sides of supporters. An example of this is from 2 recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against a harassment charge against her and her pursuit of a counter-harassment charge. Yesterday, this reporter posted about, quote, getting protection from another blogger, see Exhibit 4. While I do not know the facts concerning these court appearances, it is very evident that individuals on all sides of this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the courts from other individuals. In light of the mistrial, there is no end in sight to this irrational behavior, which clearly continues today. Jurors will undoubtedly be the subject to harassment and likely physical confrontations if their names are made public. It goes on to say, my affidavit and motions should not be interpreted as indicating how I or any other juror voted in this case, or how I or any other juror felt about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. It was an honor to serve on the jury. It was also a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer not to have to respond to those inquiries. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on the jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family. Signed under penalty of perjury, the 16th day of July. Holy new filings, law nerds. There were 3 things we went over in the Karen Reed case unexpectedly this afternoon. First, a juror came forth with an affidavit because the court had sealed, in Massachusetts they call it impounded, the jury list from July 8th to July 18th. July 18th is today. The juror, through their attorney, filed an affidavit stating that they are concerned for their own safety if the jury list were to become public on July 18th today. The juror indicated that that fear stems from articles they've seen in the media, videos they've seen posted on X, and statements they've seen of people maligning the judge, making strong and vitriolic statements about the jurors, about their deliberations, and they made clear that they have concerns for both those that think Karen Reed should be acquitted and those that think Karen Reed should be convicted, and that they were making no statement about any one side of the issue, but that they were afraid for their own safety, their family's safety, that they would be harassed, that they would be doxxed, that they would be confronted publicly for those who have very strong opinions on either side of this case. And that if their names become public, that they will not be able to adequately protect themselves or their families. And they cited quite a lot of examples. The court considered that affidavit in granting a new impoundment sealing order and sealed the jury list indefinitely, saying that until further order of the court, the jury list remains private and sealed. But that ruling makes clear that jurors are allowed to speak about the case and jurors are allowed to identify themselves to the media or whoever they wish. But it gives the choice to the jury, not to the public. They cited concern that people connected with the case had been charged with intimidation. They said that they were concerned that witnesses that testified in the case testified that they had been harassed, and the concern for seeing not only the media saying that there is rising rage in this case, but also that people were attacking a sitting judge made them feel vulnerable to also being attacked verbally and perhaps physically, or that a verbal confrontation leads to a physical confrontation. And the court found that that was credible and that those fears are founded. Then the defense filed a motion today with a fifth juror that has come forward, Juror E. This is the third juror that has spoken to Alan Jackson. And this juror confirmed that the jury had reached verdicts on counts 1 and counts 3, and that they were undecided as to the lesser included counts on count 2. Remember, those lesser included counts on count 2 include the chain of events counts. Did Karen Read start the chain of events that led to the death of John O'Keefe? So it's understandable that when they're hung as to those lesser includeds don't necessarily say, did Karen Read hit him with the car? Did she leave him there? There's a lot of room in those lesser included instructions for multiple possibilities, and the attorneys didn't address them in closing at all. They addressed other things. But it's clear in these affidavits from Alan Jackson that 3 jurors have reached out to him and said, no, we reached verdicts on counts 1 and 3. The court's back in court for a trial setting date on Monday, and the defense is going to continue to argue that the court must dismiss counts 1 and 3, that Karen Read cannot be retried on those counts because the jury reached verdicts. And he offered in this filing that if the court wants to do that by affidavit, allow the jurors to submit affidavits instead of being questioned. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.